morning, everyone. My name is Judge Ruppe, and you are all here this morning for first appearance. The purpose of this hearing is to inform you of the charges against you and determine whether there is probable cause for your arrest. Probable cause only means that it's more likely than not that you committed the crime in which you've been arrested. As you stand here before me today, you're considered not guilty of what you've been charged with, and that status will remain with you through each stage of these proceedings up until changed by you if you fiance your case or the state attorney's office if they prove the case against you beyond and to the exclusion of every reasonable doubt. In all likelihood, you were arrested on a new charge or a warrant. Either way, you were given a bond pursuant to the bond schedule for the 5th Judicial Circuit. I will determine whether to keep that bond the same, increase it, decrease it, or whether there are any other conditions of pre-trial release which will be imposed upon you. I will determine this morning whether you'd like to hire a private attorney, whether you'd like to represent yourself, or whether you'd like the assistance of the Public Defender's Office. You are entitled to have an attorney represent you at each stage of these proceedings, so if you cannot afford to hire an attorney, I will appoint the Public Defender's Office for you this morning. You are also entitled to make a phone call to let friends, family, or your attorney know where you are. If you haven't been able to make that phone call yet, please let me know. I'll make sure that happens this morning. Finally, and most importantly, you have the right to remain silent, and I encourage you to do so. These hearings are recorded, and there's an assistant state attorney in this courtroom writing down everything that you say. So anything you say about the facts of your case can and will be held against you in the prosecution of your case down the road. At this time, I'd like everyone to raise your right hand so I can place you under oath. Swear or affirm the testimony before the court this morning will be the truth, whole truth, and nothing but the truth. Go ahead and put your hands down. As I call your name, please come forward to the podium. Jessica Aviles. Ms. Aviles, can I have your date of birth?
January 16th, 1994.
You are here this morning because you failed to appear in front of Judge Toner on January 2nd for a possession of controlled substance charge. I did find probable cause for your arrest. Did you have the public defender representing you in that case?
Yes.
Okay. I'll make sure that they are still on your case. And we are going to see you, we're going to keep the bond at $10,000. We'll see you back to court on February 12th at 8:30 in the morning, okay?
Yes, thank you.
Okay. David Brown.
Good morning, Your Honor.
Good morning, Mr. Brown. How you been?
All right.
Okay. Well, you are here, as you know, for a trespass. I did find probable cause for your arrest. I am familiar with Mr. Brown and his record, but I don't know if you have a plea offer today or not. If you don't, we'll just lose that.
Just as an incentive, my inclination would be the 60 days, which would be the max, but if he was willing to resolve it today, it would be 30.
Okay, Mr. Brown, if you want to resolve your case today, the state's going to give you 30 days from Anna County Jail. Is that something you want to go ahead and do today?
No. Would they possibly accept 10?
No. State, the counter offer is 10.
Well, I was inclined to do 60, so...
The counter offer from the state is 60. Do you want to do 30? Or do you want to set it up for another day and have time to speak to your attorney?
No, we'll go ahead and resolve this morning.
Okay. You understand by taking a plea on this case today that you're giving up your right to go to trial?
Yes, I do.
Okay. You're giving up your right to confront witnesses against you, call witnesses on your own behalf, and you're giving up your right to have the state prove the charge against you. Want to give up those rights in order to take care of this case today?
Yes, I'd like to take care of it today.
With regard to this trespass, how do you plead? You can plead no contest.
No contest.
Accept your plea of no contest. I find it's freely and voluntarily entered. Adjudicate you guilty. Send you to 30 days from Nanda County Jail. I'll give you credit for the 2 days that you have in. You'll have fines and court costs in the amount of $503 that will be assessed against you. We're also going to assess the cost of incarceration. Once you do get out, I would tell you to make a payment plan, but I can see all your other pending cases that you have never been able to do so. So those charges will be assessed against you, and maybe at some point you'll be able to pay those. Good luck.
Thank you.
Robert King. Mr. King, what's your date?
Good morning, Judge.
Good morning. What's your date?
6/19 6/1987.
You're here today charged with domestic battery. Looks like against your mom. I did find probable cause for your arrest. Do you want to represent yourself, hire somebody, or do you want the public defender's office?
Public defender.
I'll appoint the public defender's office to represent you. State to see requirement.
Yes, sir. Yes, ma'am. There's a showing a registration out of 2014. There's a possession of controlled substance, Fernando 2013 adjudication, as well as cannabis and paraphernalia. In 20 grand theft adjudication, Hernando 2012, burglary of unoccupied structure, conveyance, cannabis, Hernando 2011, grand theft 2011, Hernando, and cannabis, paraphernalia, oxycodone, prescription without, possession without, of a substance without prescription, February 2011. Most of it appears to be substance abuse related, Your Honor.
Mr. King, I have an address here in Toucan Trail in Spring Hill. Is that where you live?
Yes, ma'am.
How long have you lived there?
Quite a while now, ma'am.
Do you have a job?
No, ma'am.
Okay. Were you living with your mom on the Toucan Trail address?
No, that's my grandmother.
Your grandmother?
Yes, ma'am.
Were you, and that's who you were living with, your grandmother?
Yes.
Okay. I'm going to order that you have no contact with your grandmother, Deborah King Seymour. If you have any contact with her while this case is pending, then you will be charged with another crime, and you will be held without bond until you resolve all of your cases. Do you understand that?
Yes, ma'am.
Okay, do not call her, do not write her, do not email her, and do not have anyone else call her, write her, or email her on your behalf. That means even if she calls you or tries to have contact with you, you're still ordered not to have contact with her. So if she calls you, you should hang up the phone. If you see her out somewhere, you should turn around and go the other way.
Yes, ma'am.
I'm going to hold you until 4 o'clock today in case Ms. Seymour wants to file an injunction against you. If she does file that injunction against you, you want to make sure to read that paperwork carefully because it will be very specific as to the amount of feet you need to stay away from her, her home, her work, or anywhere else where she may frequent.
Thank you very much, Judge.
I'm going to give you a bond of $5,000. You're welcome. We'll see you back to court February 7th at 9 a.m.
All right. Have a good one, Judge.
Good. Okay, they brought up Milton Delane, who was on the 1:30 calendar call.
She's talking.
What are we doing with Mr. Delane's case? Mr. Delane, are you there? Come on up.
Judge, he also has a felony pending, but it is a request. We're on the trial docket. I don't have my agreement file down with me, but my understanding the state's asking for 60 days. He has that in.
That's correct.
Mr. Delane, you want to resolve this for time served today, or you want to have your trial next week?
Time, sir.
Okay. That'd be 60 days time served, Judge. He has not been sentenced to the felony yet. That's still open, isn't it?
Yes.
Okay, and it's not a bop, this isn't going to affect the felony?
No, it's not involved. It's
Okay.
a new charge.
Okay. Is the driving suspended?
Yes.
Okay. And just make sure I have the right case number, 2017-2298-CT. That's the case. Is that right? Yeah. Okay. All right, Mr. Delane, you want to resolve your case today?
Yes, ma'am.
Okay. Were you here when I placed everyone under oath? Did I already do it? Were you here when I placed everyone under oath?
Yes.
All right. Do you understand that by taking a plea on this case today that you're giving up your right to go to trial?
Yes, ma'am.
You can put your hand down. You're giving up your right to confront witnesses against you, call witnesses on your behalf, and you're giving up your right to have the state prove the case against you. Want to give up those rights in order to take care of this case today?
Yes.
Okay, with regard to this driving and suspended charge, how do you plead and plead no contest?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily entered, adjudicate you guilty, sentence you to 60 days for Hernando County Jail. You're going to find the court cost the amount of $438, the cost of prosecution, and the public defender fee assessed against you. When you do get finished with your cases, you want to make your way down to the clerk of court, make payment arrangements for all of those things, okay? And I'll strike it from the calendar call and trial docket.
All right.
Yes.
Thank you.
Yeah, 60
60
days for time served. And we also have from the 9 o'clock docket, Nathan McKee. And we RCO'd him, I think, last week at some point, right?
Yes, Judge, we just got appointed last week, so we haven't gotten any discovery on that yet. These are 2 driving on suspendeds.
What are the case numbers? Was it 2018 CT 174 and 2017 CT 3499?
Yes,
That's correct, Your Honor.
Okay. All right, are we resolving these, or are we setting them both off for another case?
Mr. McKee, the offer from the state's 60 days. You only have 7 in. Do you want to resolve this today, or do you want to continue it? Let me get the discovery and come out and speak with you about that.
Might as well go ahead and resolve it today.
Okay.
I can't take probation or anything. I have a 5-month-old daughter. No provider for me.
Your Honor, the state's not willing to do probation. He was on the DL docket on a driving while license suspended, then obtained another driving while license suspended.
Trying to get to my daughter to take her to the hospital.
He had an adjudication for no valid driver's license in May of last year. He was, released in 2016. It looks like on manslaughter charges. He had a Willis prior.
I think he was a witness in that case. That was not his.
Okay. But he had a prior Willis also from 2014. But
Okay. All right, well, the state's offering you 60 days today. If you don't want to take that, you don't have to. You can have some time to speak to your attorney, and we'll put you on the docket again in a couple weeks. What do you want to do?
And where's my attorney advice?
Excuse me, sir, what did you say?
I said, what do you think I should do?
Well, that's up to you.
I'm not.
I'm not going to tell you, just like the judge isn't going to tell you to do one thing or the other. If you think you have a defense to these, I'll certainly come out and talk to you about it. Pretty much the defenses are it wasn't me driving, or I do have a license. And the state is right. You did have, back in May, you got 1-day time served. That's why they are sticking with the 60 days. What do you want to do?
Go ahead and resolve it today.
Okay. So that would be 60 days with credit for 7.
Sir, do you understand by taking this plea today that you're giving up right to go to trial?
Yes, Your Honor.
Giving up right to confront witnesses against you, call witnesses on your own behalf, and you're giving up right to have the state prove the case against you. You give up those rights in order to take care of this case today?
Yes, Your Honor.
Okay, with regard to this two driving on suspended driver's licenses, in 2017 CT 3499 and 2018 CT 174, how do you plead? And say no contest.
No contest, Your Honor.
Accept your plea of no contest. I find it's freely and voluntarily entered. Are we just going to do the 60 days on one of them and time served on the others?
That would be fine.
Okay.
Fine, Your Honor.
On the 2017 CT 3499, adjudicate you guilty, sentence you to
7.
7 days, Hernando County Jail, 7 days credit for time served. You have $438 fines and court costs in that case. For the second case, 2018 CT 174, sentence you to 60 days, Hernando County Jail, give you credit for the 7 days that you have in. You have fines and court costs amount of $438. You're also going to have the public defender fee and the cost of incarceration, okay? When you do get out, and you will make your way down to the court, make payment arrangements for all of those things, okay?
Thank you, Your Honor.
All right, did we get everyone in custody? Oh,
No, Your Honor. We still have one on the first appearance docket for waiver of extradition, Charles Barker.
do you guys have any paperwork on Mr. Barker?
Judge, can I also bring something to your attention?
Sure.
17 CT 4517 is a KBS. I don't know if we can confirm with the jail that they've actually arrested him on that, but that
Is this for
would be
Mr.
resolved.
Barker?
Yes, ma'am.
Okay. What are you asking, whether he got served with a warrant from Hernando?
Yes.
Okay.
There's an FTA, and if so, we can resolve it if we want.
Okay. Do you guys at the jail there know anything about an FTA for Mr. Barker?
No, we just have him in custody for the fugitive from justice charge.
Okay. Apparently there's an outstanding warrant for him, is what the prosecutor's telling me, out of Hernando County for an FTA. So once we can get him served on that, we can resolve that case here.
I can look into that.
Okay.
Did you?
We do have a case number if that helps. Do you, what is the case number?
17 CT 4517.
Okay. All right, Mr. Barker, for this morning's purposes, it looks like, do we know what state is looking for him?
Missouri.
Missouri? Okay, looks like the state of Missouri is looking to come get you for some charges out of there. You have two options this morning. The first option is to set an extradition hearing. We can set that up within 60 days. At the extradition hearing, Missouri would only have to prove that you are the right person that they are looking for and that they do have a valid warrant for your arrest. If they do prove those two things, they will take you from our custody at that point. Your second option is to waive that extradition hearing and give Missouri, put them on the clock, and give them 15 days to decide whether to come and get you. Do you want to go ahead and put Missouri on the clock today?
Yes, to 15 days.
All right, we'll give them 15 days, all right?
All right.
All right. I'm going to have you sign some paperwork right there. All right, thank you, Mr. Barker. We might see you again tomorrow morning because it looks like there might be an outstanding warrant for your arrest. If that's the case, we'll see you tomorrow morning and perhaps we can resolve it at that time, okay?
Okay, thank you.
All right. Yeah.